The ledger of public trust in New York has just been flagged for a systemic audit failure that threatens to liquidate the remains of a once sterling legal career.
Well, hold on there, Tishy Tish, because justice may just start raining down on you like water. That's because the Trump-hating New York State Attorney General is once again being referred for criminal charges to the Department of Justice for alleged funny business involving her two homes, big real estate magnate, in the same state, the state of Virginia. What's up with that? She lives in New York, where she's Attorney General. She's required to live there under state law. Federal Housing Finance Agency Director Bull Pulte, that's right, Bull Pulte, claims that Big Tish may have falsified information on more than one occasion with insurance companies in Florida and in Illinois. That shouldn't be a problem. She's got Democrat Party protection in one of the two letters sent yesterday, this one to the U.S. Attorney for the Southern District of Florida. Pulte includes evidence of an application for home insurance submitted by Tishy Tish there with a Fort Lauderdale-based company. That's peculiar. Claiming that her home in Norfolk, Virginia would be unoccupied for 5 months of the year, but Tish's niece told a grand jury that she was living in that home rent-free for 5 years. For 5 years, not living in New York, like she said. And in another letter, this one to the U.S. Attorney for the Northern District of Illinois, spreading all over the place. What a nation we have.
We are witnessing a forensic inflow of criminal referrals that target the very individual tasked with being the state's primary auditor of integrity. When the chief law enforcement officer of New York is referred to the Department of Justice for occupancy fraud and premium arbitrage, we aren't just looking at a political headline. We are looking at a total breakdown of internal controls. The brand equity of the New York Attorney General's office is now in a state of technical insolvency, and the results of this federal audit will determine if the chief law enforcement officer is actually a high-risk liability to the rule of law. I am Camilo Motato, and this is Camilo's House. As a certified public accountant focused on forensic verification, I approach every criminal referral like a management letter of significant deficiencies. In a standard audit, if a CEO is found misrepresenting the usage category of a primary asset to lower its carrying costs, you immediately flag it as material misstatement due to fraud. Today, we are performing a premium arbitrage audit on Letitia James. We are documenting the two criminal referrals sent by Federal Housing Finance Agency Director Bill Pulte to the Department of Justice on March 25, 2026, alleging suspected homeowners insurance fraud across 3 different states. We are analyzing a scenario where the chief prosecutor is accused of phantom residency, claiming to live in Virginia while holding a sovereign mandate in New York, all to secure a lower insurance premium on the backs of the private market. The operational trigger for this crisis is a series of related party transactions involving James's real estate portfolio in Norfolk, Virginia. According to the FHFA referral, Letitia James may have falsified information to insurance companies in Florida and Illinois. From an investigative standpoint, the materiality of these claims hinges on the occupancy status of her Virginia properties. In any risk-rated market, the presence of the asset owner is the primary driver of value. Insurance companies calculate their actuarial risk based on whether a home is owner-occupied or non-owner-occupied. When you misrepresent a rental asset as a primary residence, you are performing premium arbitrage. You are undercutting the market by securing a lower cost of capital for your insurance coverage through a fraudulent disclosure. To understand the forensic logic of insurance fraud, we have to audit the DP3 policy ledger. A standard homeowner's policy is designed for a property where the owner actually lives. Insurers view these as lower-risk assets because the owner is present to mitigate loss. Consequently, the premium expense is lower. In contrast, a non-owner-occupied property is a high-risk asset that requires a DP3 policy, carrying a much higher risk premium. By claiming her Norfolk home was owner-occupied when she was allegedly sovereign in New York, Letitia James was reportedly manipulating the ledger to avoid these higher carrying costs. This occupancy fraud is the downstream crime of her previous mortgage fraud allegations, claims that were liquidated on a technicality last November when a judge ruled the prosecutor was unlawfully appointed. The audit trail provided by Director Bill Pulte includes primary source evidence that contradicts James's internal reporting. In the referral to the Southern District of Florida, Pulte cites an insurance application where James allegedly claimed her Virginia property would be unoccupied 5 months out of the year. However, the referral alleges the house was actually occupied year-round by her niece. From a forensic accounting perspective, if the niece is in the house, the asset usage is non-owner occupied. If James is claiming to live there to get a better rate, she is reporting a phantom residency. Even more damaging is the occupancy variance reported to Allstate in the Northern District of Illinois. The referral alleges that James claimed her property would be occupied by a single adult with no children. Instead, according to the documents, she allegedly knew the house was occupied by 4 people, including 3 children. In the world of risk management, the density of occupation directly affects the liability profile of a property. By redacting the residence on her application, James was obscuring the true risk from her underwriters. This is a material misrepresentation intended to defraud the insurer of the correct premium revenue. We must also audit the jurisdictional conflict of the Chief Law Enforcement Officer of New York. Under state law, the Attorney General is contractually required to be a resident of New York. If the DOJ audit proves that Letitia James was claiming her primary residence was in Virginia for insurance purposes, she has created an insolvent narrative. She cannot be vested in New York for her public salary while being vested in Virginia for her private insurance. This is a management override of ethics that suggests she was cherry-picking jurisdictions. It is the ultimate conflict of interest, prosecuting the Trump Organization for asset overvaluation while reportedly undervaluing her own liabilities to cheat an insurance company. The technicality dismissal of her previous mortgage fraud case in November 2025 was a failure of judicial controls. The case was written off because the interim U.S. Attorney, Lindsay Halligan, was ruled to be unlawfully appointed. This administrative default allowed James to skate on the charges, but these new referrals are a new round of forensic testing. Her attorney, Abby Lowell, has labeled these as baseless allegations and a vendetta, but as a CPA, I know that just because you dismiss the indictment doesn't mean the underlying deficit goes away. These are federal crimes that carry significant penalties, including potential asset forfeiture and prison time. The social and political cost of this Tish James audit is a total impairment of public trust. When the chief prosecutor is seen as ignoring the law, the social contract enters a state of default. If the DOJ fails to prosecute the referral, they are certifying a 2-tier ledger where the management at the top is exempt from the regulatory requirements that every other citizen shareholder must follow. This market inequality is the primary crisis facing the American Republic today. My forensic verdict on the Letitia James insurance fraud referral is that we are witnessing a systemic management default. The evidence of falsified information on insurance applications is a material fact that requires a full-scale prosecution. You cannot audit the world for fraud while hiding your own liabilities in a Virginia shadow ledger. The premium arbitrage she reportedly performed is a theft of revenue from the insurance providers and a breach of fiduciary duty to the people of New York. Until the DOJ performs a hostile takeover of this investigation and reconciles the records, the integrity of the AG's office remains non-existent. The technicalities of the past may have provided a temporary shelter, but the insurance ledger is a binary system. You either lived there or you didn't. The alleged niece's residency and the occupancy discrepancies are the source documents that will liquidate the defense. Tish James may have assumed she could get away with it, but in a forensic audit, the receipts always find a way to the surface. I want to hear from you. Is the technicality dismissal of her first case a material weakness in our justice system, or was it just standard operating procedure? Does occupancy fraud for lower insurance premiums constitute a removal level offense for an attorney general? Let me know in the comments. Your perspective is the only audit that matters when the chief law enforcement officer and the fiduciary trust of the state are sitting on the negotiation table. I am Camila Motado, and this is Camila's House. Subscribe to stay informed on the numbers, the laws, and the truth behind the headlines. Stay safe.